This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. I'm Stuart Address. This is Ask a Lawyer. Another Friday edition. I won't be here next Friday because I will be in Gainesville at the University of Florida with my son, who will be participating in a national debate tournament.
All right. You'll be in Gatorland.
I'll be in Gatorland for the first time. Never been there.
Yeah. Well, I'll just be a few blocks away from you at one of the state colleges. Yeah, right around the corner, as a matter of fact. Yeah, very cool.
And let's see, folks. Give us a call at 340-1590. Ask me a question about yourself, a friend of a friend, or anything that interests you, and I'll see if I can either help you or have an interesting legal conversation with you. That's 340-1590. Now, I'm going to start with a completely irrelevant off-topic story. I see that on Facebook. I have a certain somebody who has tuned in, and this takes me back 46 years ago. No, I'm sorry. 45 years ago.
A little before law school.
Yeah, just a little
Yeah,
bit.
just a little bit.
And I was a high school student in New Jersey. And back then, we had these things called snow days.
Snow?
Yeah, snow.
What's that?
I know a lot of people here probably are not familiar with it, unless you're from South Florida, in which case you are very familiar with it from your past reincarnations. Anyway, so I had a friend, a high school friend, who, whenever we had a snow day, we would get on the phone. Back then, you couldn't use your cell phone or anything.
There wasn't any.
Had to use your landline corded phone. You were lucky if you had these princess phones that had push buttons. And we would stay on the phone while we would watch the Addams Family together. And I can hear myself in here, but I can't hear you, so you may want to make an adjustment in case we do get a call. And so we used to watch the Addams Family, and it was a lot of fun. And I've reconnected with this woman several years back who worked in Palm Beach County for quite a long time. I moved to Florida as well. I wasn't aware of that. And so we have made arrangements, her and her husband, and my girlfriend and I, in a couple weeks to go together to see the Addams Family.
That's going to be a movie or something this time.
It is a movie.
Yeah.
In the theater.
I saw the promos,
So from 45 years ago on TV during snow days to the movie theater here in Florida, life continues.
I love it. That's great.
It comes back in mysterious ways.
That's funny. Yeah, good stuff.
And let's see. We've been talking about so many different things, and we have been sidelined by political legal topics.
We have?
We have.
Name one.
No,
don't go there.
Name one. I don't know. Which one trumps them all?
Oh, no.
See, that's called a lawyer thinking on his feet.
Yeah, that was quick.
And we've talked about things that occur in my office, calls that we get. So I thought we would do that a little bit more today and see if we can inundate Sadia with phone calls at the office. So if you want to call the office instead of the show, It's 781-8003. And if you want to talk to me a little bit here on the show, it's 340-1590.
I like talking to Sadia.
Sadia is very nice.
Sadia is very nice. Oh, yeah. And thank you for last week's show, by the way. Oh, man. Very timely.
Very timely. So we have gotten a lot of calls again this week, last week. A lot of them really are small claims court calls. You know, people don't realize that what really they have is a small claims court case. And, you know, we really don't handle those per se because it's not cost effective for the client or for us. But we do try to give a little bit of advice on the phone. And sometimes we have people come in for a consultation where we'll work with them on the small claims court packet and give them advice as to how to present their case in the 10 or 15 minutes they get in front of the judge.
What is the level of a small claim?
I am so glad you asked, my sidekick Ed McMahon.
Yeah, oh, no. Yes.
A small claims court goes up to $5,000. County court is $5,000 to $15,000. Circuit court is $15,000 and above. Now, county court is this sort of Netherland world where you don't really need a lawyer, but you need a lawyer because it's real court. A small claims court, you really don't need a lawyer. Now, some people are not as comfortable going in and handling it on themselves, and so in that situation, it may be a good idea to get a lawyer that really handles lots of small claims court matters. And honestly, that's not me. You know, there are lawyers who, if I happen to go to occasionally to a small claims court docket call, there's a lawyer or lawyers there that have 20 or 30 clients that same day. They have economies of scale.
Yeah, if you have those numbers, yeah, I would imagine.
And the judges give them deference in terms of calling all their cases at once. So, you know, those are the attorneys that can effectively go into court with you and handle it for a decent price. I can give you some advice, and if you're comfortable handling things on your own, I think I may be able to give you better advice, honestly. But if you need a lawyer in there, you need somebody who has a lot of clients at the same time doing that. But so let's talk a little bit about small claims court. Because it seems to be, you know, it's the place that, you know, I hate to use this phrase, but it's the people's court. It's where you can go with a small monetary dispute and try to handle it yourself without having to spend an arm and a leg with a lawyer. And who wants to give up an arm and a leg?
So is it Judge Judy there? There's the judge?
Oh, please don't.
Oh.
Please don't.
Okay.
I have an animosity towards Judge Judy.
She's actually very nice.
I can't stand... I don't know if that's what's her demeanor in real court or if this is just pretend for TV, but I can't stand... She's a pain in the you-know-what.
She's very nice off camera.
All right,
I can tell you.
I'll take your word for it.
Yeah.
Maybe one day she'll prove it to me. Because she's so curt and abrupt. And
yeah.
That's not a judicial demeanor. That is the type of demeanor that would scare people from going into court.
Oh, okay.
Yeah. That's one of the reasons I don't like her. Okay? She doesn't give people time to talk. She cuts them off. She tells them, I don't believe you. She's nasty. And folks, that's really not the way it is in most small claims courts. You may get a judge like that here and again, but for the most part, that is not the way it is. For the most part, they're pretty helpful because they realize you're there without a lawyer and because the rules of evidence are relaxed in small claims court. So if you don't do it precisely right, the judge may help you along just a bit.
So they're not going to get you on a technicality or something if
they
you
try not to.
Flub.
I mean, you have to know some things, but they try not to. So here's the way, you know, it really works. Let's say you're the one with a claim. Let's say some roofer, you know, has beat you out of, you know, $2,000. And and they're not returning your calls, they're not responding to your letters. What to do? Well, and since it's a roofer, there's a couple things to do. You could file a complaint with the Department of Business and Professional Regulation, and they'll investigate that roofer, and he may have a real problem with his license in the future. But let's assume it's, somebody else that owes you $2,000. A small claims court is the place you go. So where do you start? One of two places. Either you go to the courthouse and you pick up what's called a small claims court packet, a packet of documents which includes instructions.
This is at the clerk of the court's office?
Clerk of the court's office.
Okay, gotcha.
They have these packs by the thousands.
Okay.
And it's not a thick pack, folks. I think it costs $10. It's a packet of documents, statement of claim, pretrial order, and instructions. The instructions are in plain English. They're simple. The statement of claim, which is your complaint, is simple. There's nothing fancy about it. The whole idea, it's not supposed to be magical. You're not supposed to worry about using magical legal terms. You just explain in a few sentences what the issue is, and that starts the case. Now, I can draft a fancy complaint for you. Is it really any better for the judge? If you have to go to a trial, maybe, because then the judge may read it. But when you go to what's called the first appearance, no, because the judge hasn't read a thing. So this is what happens. You file your complaint. A week or two later, the clerk, not the judge, the clerk, sends out this pre-printed form that's called a pretrial order. And it tells you and the person you're suing, and they serve it on that person, be in court on such and such a date at 9 a.m. for pretrial conference. And it actually says, I think it actually says it in bold, you will not be trying your case at this time. This is not for trial. So what happens then? You show up, and the judge calls the docket, which means calling every case that's listed, figuring out who has attorneys, who doesn't have attorneys. And there are usually between 3 and 7 other attorneys that have volunteered their time to be mediators. They're sitting in a jury box. And one by one, the judge sends you with one of these attorneys to a room to mediate.
What if the other person doesn't show at this thing?
All right, that's a whole nother story. If the defendant doesn't show, you win by default. If you as a plaintiff don't show, the case is dismissed.
Okay. Well, yeah, that seems obvious. Yeah.
Then
you don't care enough about your own case.
If you win by default, now we have to deal with collection, but we're not there yet. So let's say both parties are there. Let's say neither party has an attorney. So you're going to be given a mediator, an attorney. You're going to go into this room. The attorney is going to explain to you, look, I'm a mediator. I'm volunteering my time. My job is to listen to both of you, try to understand what's going on, give you my best sense of what's likely to happen if you go to trial, and try to help both of you resolve this right now so that you never have to come back here again. And that's essentially what the mediator is going to tell you. So then you're going to sit down, opposite sides of the table, and the plaintiff's going to go first. Tell me about your case. 2 or 3 minutes. Doesn't want you to go on for an hour.
Okay.
Because in a small claims court case, you can really tell your case in 2 or 3 minutes. Again, it's going to turn to the other side, the defendant. All right, what do you have to say? You're going to listen to the defendant. 2 or 3 minutes. Then, probably, since this is a small claims court, you're not going to break apart into separate rooms. You're going to stay together. And the mediator is going to ask some questions of both sides. and try to get a little bit more information that he or she believes is needed to help them as an attorney make an analysis of what would they be doing if you came to them as a potential client. What would they be telling you? And then that mediator is going to give you his or her impressions. Not necessarily you're going to win or you're going to lose, but you're going to have to come back again. You're going to have to take the time to go in front of the judge. You're going to have witnesses. You're going to have your documents ready. So, here's your chance to solve this case yourself. All right, having listened to both of you, this is what I see. I'm going to tell the plaintiff some points that help them and tell the defendant some points that may help them, or maybe there's no defense at all. But the mediator is going to be relatively frank and then say, how can we fix this? Now, you're suing for $2,000. The defendant doesn't want to pay you a penny. I don't know why, some excuse. You didn't let him into your house. You tried 4 times. I don't know. And so the mediator is going to try to get that guy to come up and you to compromise a little bit just to avoid the inconvenience of having to come back. So let's say you settle at $1,250. It's going to be written up. You're both going to go back into the courtroom. You're going to let the judge's clerk know that you've reached a settlement. The judge is going to come out in his or her robe, and you're going to go on the record and say, yes, we've reached a settlement. Is it written up? Of course it will be. May I see it? The judge is going to look it over to make sure it has everything it needs to have in there. The judge is going to say, fine, I'm going to sign this. And defendant, if you fail to comply, here are the consequences. Goodbye. Have a good life. Hope you never have to be back here again.
So he doesn't have to cut a check then?
It's nice if the defendant does, but no, they don't have to. If the agreement is you're going to pay me $1,200, you're going to pay $300 a month for the next 4 months.
Oh, I got you. Okay.
Whatever the agreement is.
Okay.
So then you leave, and as long as the defendant does what they're supposed to do, you're never going to come back again. And it's done with. Now, did you really need an attorney to go sit with that mediator who's also an attorney? Honestly, in most cases, no. Would it have been worth the money to pay somebody like me for a consultation? If it was $5,000, maybe. $2,000, probably not. If it gives you a comfort level to talk to a lawyer first, then it's worth it. I mean, it really all depends upon each individual person. As I've always said, there are people that will go to Vegas and put $1,000 on red, and I might go to Vegas and put $2 on red. We're all different. You want to talk to a lawyer first? You have every right to do it. Issue is cost. So now what happens if you go and you sit with that mediator and you just can't reach an agreement? Okay. Now you're going to be sent back again into the courtroom. You're going to tell the judge's clerk we did not reach a settlement. Judge's clerk is going to say, fine, we will send you another order with a trial date. You may now leave. You don't even see the judge. Clerk just makes the notation, not settled, and you all leave. So another couple weeks later, you're going to get another order in the court by mail. And it's going to say, show up on such and such a date for trial. So now realize, the first time was a pre-trial. A lot of people think they're going there to try their case. You're not. You're going there to mediate. It's only if you don't settle, you're going to get another order in the mail. And that is for trial. Now,
how long does it take from the first order to the second order?
A couple weeks.
Oh, they're relatively quick then.
Small claims court, yes.
Oh, okay, cool.
And so now you have trial coming up, let's say, in 2 weeks. as the plaintiff, of course, you have the burden of proof. Now, what does that really mean in small claims court? It means in 15 minutes or so on average, what does the judge's gut instinct say? That's all it really means. I mean, yes, you have to prove by a preponderance of the evidence, which I like to say is 50% plus a feather. In reality, to a judge in small claims court, it's what's my gut say. That's 50% plus a feather. So, as a plaintiff, you do want to present your case as best you can. Now, that doesn't mean you need to, have a highfalutin lawyer. I was trying to think of a good name, but
Clarence Darrow.
Right, the names I would have used, people probably wouldn't know anymore, and I didn't want to use a real name, so okay, Clarence Darrow, or Matlock.
Yeah, that's it. Yeah, Matlock. Yeah. Perry Mason.
Right, Perry Mason. You don't need one of those to go to a small claims trial. And you probably don't need an attorney at all unless it's a little complicated with documents.
Our DC law firm at $1,000.
Right, exactly. So what's the best thing to do? If you're comfortable, you organize it yourself. These are the documents I need to prove my case. If I need a witness or two, I'm going to make sure they're there with me. And this is what I plan on telling the judge. You organize it, because the judge is not going to want to let you go on for 20 minutes. Judges want to hear in like 5 minutes, what's your case?
Okay.
You got to be succinct. You got to be prepared to be organized. You start fumbling for papers, the judge is going to get frustrated, and that's going to work against you. So, is it ever a good idea to come to an attorney, even one like me, and I've done plenty of these, pay for a consultation, and say, okay, I have to go to trial, can you help me prepare? Sure, in that hour you're in my office, if you have your paperwork with you, I can sit with you, I can say, okay, this is how you're going to prove your case. These are the documents that are important. First, you want to offer this document. This is how you do it. Then you want to go, these are the documents you want to offer in this order. You want to tell the judge these points. And either we'll type them up as bullet points or you'll handwrite them. You're going to 1, 2, 3, 4, 5. These are the points you want to make.
Do you ever try a dry run in your office? Or no?
If the client really wants it, but not rarely, because honestly, there's not that much time.
Okay.
Okay. Sometimes just by my nature, if I'm explaining, this is what you want to say to the judge, I'm going to argue it, like I'm arguing it to the judge. Your Honor, he promised to come do my roof. I called him on January 5th, February 27th, March 16th, April 4th. Here are some text messages. Here are a couple emails. He never gets back to me, and my roof's not done, and I paid him $2,000, and I want my money back. That's your case, folks. If you knew how to say, if I argued that to you in my office, and then we helped you write it all down, hopefully you then feel better prepared to go in and handle it yourself, which is the least expensive way of doing it. Even if it turns out the other side has an attorney. Because what good is an attorney in small claims court? Not much. I mean, if you're prepared and if you're right, an attorney, especially in small claims court, if they try to confuse things, the judge is just going to side with you most of the time. If the other attorney presents the defense case in a straightforward fashion, just like you did yours, the judge is probably going to want to hear from that defendant under oath. Because when you told him your story, you will have been placed under oath. The judge is not just going to want to hear from the mouthpiece, the lawyer. The judge is going to want to hear from that party.
Sure.
And that's small claims court trial. I mean, can it go a half hour? Can it go 2 hours? You tell the judge you really need that kind of time. If the judge hears what the case is about and thinks, okay, maybe you do need that kind of time, reminds me of a case of mine, the judge will probably give it to you. It may take longer to get into court. But the typical small claims court case is give or take 15 minutes, 20 minutes. That's it. You'll go as the plaintiff, the defendant will go. The judge will typically give you as the plaintiff a chance to have the last word, because that's the way it works in our system. And then the judge is going to sit back in his chair like I am right now, maybe think for a few seconds, because he's been thinking or she's been thinking all along, and say, all right, and start talking about reasons and give a judgment, say who wins, who loses, what the amount is. His clerk is writing it all down, and then you're going to be told a judgment will be mailed to you.
Now, do they have a stenographer that they have
Not
in
in small
Superior
claims court. No.
Okay.
No. I mean, you can bring one in, but an appeal from a small claims court judgment goes not to the 4th District Court of Appeals. It goes to the circuit court. The circuit court has appellate jurisdiction over small claims court.
Oh, okay.
Otherwise, can you imagine 5,000 small claims court cases going to the District Court of Appeals?
Well, how many cases does a judge hear in a day?
For trial or for docket call?
I don't know.
On the first time when you're going in for mediation, there could be 50.
Wow, oh my God. Wow.
A lot of them won't show up because they solved it themselves and they just never bothered to tell the court.
Okay.
If it's a trial day, I don't know, maybe 10, 15. Judge may try to squeeze in because judge wants to move his or her docket just like anybody else.
Mm-hmm.
How many of these get appealed? Not many.
Yeah, that was my next question.
If you're going to appeal to circuit court, now you're going to be paying an attorney like me. And A, it had better be worth it, and B, it had better be a situation where there's an agreement and there's an attorney's fees clause in there that says the prevailing party gets their attorney's fees. Because otherwise, you're going to lose even if you win. I mean, that's reality. It's an unfair reality in our system when it comes to the cost of litigation, but it is a reality. And very often, that's a reality I have to explain to prospective clients. Even if it's not small claims court. Let's say we're in circuit court, they have a $25,000 case. Those are tough to try and litigate economically. Because if the client ends up paying me even $10,000 and they recovered $25,000, well, it's as if it was a contingency fee and I won. But what if it's a $15,000 case and they pay me $7,500 and they win? Well, now, I've won $7,500, they've won $7,500.
Mm-hmm.
What if they lose? Now look how much money they're out. Mm-hmm. And if there was an attorney's fees clause in the agreement, now they're paying the other side's attorney's fees. This is all an appellate court, folks. This is all if there's an appeal from small claims court to circuit court. It's not what happens in small claims court.
Okay, say you're that guy, the plaintiff, you win the case, and that roofer moves to Arizona. What happens?
Well, first of all, if you have a judgment, that judgment will follow the roofer all over the country.
Oh, okay.
There's a federal statute called the Uniform Enforcement of Judgments Act.
Oh.
And every state has adopted it. So what you would have to do, and we do have those situations, usually in larger cases, but where I get a call from somebody in, let's just say, Arizona, I have a judgment here for, $275,000, and the defendants moved to Stuart, Florida. Can you enforce the judgment? And I say, sure. Send me a certified copy of the judgment. I will file it in our court. I will prepare a complaint under the Uniform Enforcement of Judgments Act. Ask the court to enter a Florida judgment that is the same as the Arizona judgment, or to enter an order that the Arizona judgment has full force and effect under Florida law. And then if you've told me, for example, there's a truck, there's real estate, what have you, I'm going to start levying and collecting on those assets.
Ooh, okay.
And a judgment is good for 20 years, so if you find out that the guy has come up with assets 10 years later, Guess what?
You could still go.
He's forgotten about the case, but next thing you know, his bank account is frozen.
Ooh.
It's the easiest way to settle a case, freeze somebody's bank account. You have to know where they bank, because then we send a writ of garnishment, and the bank has to then freeze the account, notify its depositor that the account's been frozen, and then there's a procedure in court as to the court determining whether it was proper and who gets what money.
So then does the bank have to hire a lawyer too?
No. The bank is just a stakeholder
Gotcha.
that is
Okay.
holding the money. Bank does not want to be drawn into this.
I was going to say, oh man. Yeah.
And if somebody tries, the bank will say, we're happy to deposit the money with the court. So we're out of it. And sometimes that happens. So that is small claims court in a nutshell. When I was in law school, they had these little, and they were little books. They were like these 5x8 size paperbacks.
Mm-hmm.
Contracts in a nutshell. Civil procedure in a nutshell. They were nutshell books. They were broad summaries of legal principles that we all bought, in addition to our regular books. Because God forbid we fail to read the nutshell book, we were afraid we'd be missing something. Now, those law students who
Small claims for dummies?
Right. I guarantee you it exists.
That's funny. I've never heard of that.
And we'd know the law students who had only written the nutshell book, and the professors would know them really quickly, too. Because they'd raise their hand and answer a question. They'd give the answer with the broad statement of law, and then the professor would do, this is what's called the Socratic method. They start asking more and more questions and give you more and more facts and take you out on the limb and see, when are you going to fall? How long will you stick to your argument? Can you adapt?
Yes.
Those who read the nutshell books had no idea what to do. And sometimes the professor would even say, so how'd you like the nutshell? Because it was so obvious. Next time, read the textbook.
Ooh. Okay.
Two different types of responses from nutshell students and those of us who really worked hard. They learned their lesson relatively quickly. And, it carries through in every profession. And I say this many times. There are great electricians out there, great plumbers, great everything. And then there's good, there's average, and there's cheaters. The hard part is when you have to hire somebody, and that includes me, finding somebody who is at least very good and honest.
You see a lot of these stories on the news of like pool companies that skip
Yep.
on contracts and stuff,
Yep.
and you just think, oh my God.
In Florida, after hurricanes, special laws go into effect. Gouging, trying to go without a license. All of a sudden, these are now criminal offenses. Because Florida takes very seriously, especially after a hurricane, people trying to prey on others. And oh my goodness, if after a hurricane you try to prey on the elderly, you're looking at time.
Mm.
You're not just looking at a statute that says you can get time. You are probably looking at time.
After 2004 and 5,
Right.
I mean, we saw license plates from all over the place.
And they flooded into Florida without license, without roofing licenses, without contractor licenses. And they were everywhere. Some of them did great jobs. Some of them were charlatans. And a lot of people were taken. And a lot of money was lost. And that's when Florida really began to implement, post-hurricane laws, and also laws with regard to generally certain types of people having to have a license. Lawyers have to have a license. Well, roofers do too. Contractors do too. You're going to do electrical work, you better have a license. Things have to be up to code. You need to pull a permit. A lot of these people don't pull permits. And all of a sudden the homeowner finds out later on when code enforcement starts finding them or telling them, rip out your patio.
Or your
there was
water
never
heater
a permit,
or something.
right.
Yeah.
And you literally got to rip it out. Judges will enforce that because it was done without a permit. And then you go to sue and you can't find them anymore. It's a bad situation. So the motto has always been buyer beware. The same thing with all these crazy, crazy telephone solicitations. This is the IRS.
Oh.
This is Microsoft. We've determined that your computer has a virus. Buyer beware. Now, look, we're not all the same. I can be gullible in a certain area, and there are areas I may not be gullible. Another person may think the area I was gullible in, boy, was I stupid, they may be right, because that's not the area they would have been gullible in.
I got an email from our bank, and I went in.
Was it from a prince?
Yeah. Yeah, well, it almost was that bad. And, and the bank said, no, we didn't say anything out. So somebody phishing.
Absolutely. Absolutely. It's unfortunate, but you've got to be suspicious of everybody. They make contact on the phone. If they say they're Apple, you say thank you, you hang up, and you call Apple. And if it was really Apple, they'll be able to figure out with whatever information you have that they called you and tell you what it was all about. Microsoft, same thing. The IRS, they're not going to be calling you. Trust me. You'll be getting a letter in the mail.
Yeah, that's it. Yeah. Such pretty letters, though.
Letters that instill fear.
Oh, yes.
So, it is buyer beware. It's unfortunate. It's a horrible way to have to live, but it is the truth. It is reality. Maybe I was wrong when I said you need to be suspicious of everybody. You need to be cautious. You need to be prudent. You need to check. Don't ever give anybody the last four of your social, because if they have other information, they'll use it. There's even devices, I kid you not, where you'll be asked a question, and if you answer yes, they now have you recorded with that yes, and they will use that to open up accounts, to charge. All they wanted was you to say yes to a question. Even I may fall for that, depending upon what the question is.
I know it's difficult. Yeah.
Not every, and there comes in another point, folks. You happen to fall for something like that, you are not stupid. Don't let anybody make you feel like you were stupid. Don't be embarrassed to go complain to the police or to call a lawyer. Nobody is perfect. You make a mistake and you give out information you really shouldn't have given out. Okay, maybe somebody in your family might call you stupid. Don't let anybody else. I mean, it's going to happen to all of us. And, what might not happen to me might happen to you. What you might be on alert for, I might be gullible for. So we deal with things the best we can. Something goes wrong, you call the police, you call your credit card company, you call the bank, you call a lawyer. Depends upon what the situation is. And that's part of our life today. And that's something that Trump didn't create. Oh, gosh.
It was that Russian company that made all the voting machines in Brevard County. Did you see that story?
No.
Yeah. Their voting machines in Brevard were purchased from Russia.
Well,
I'm sitting there going,
If
no.
I'm the Florida legislature, I am entering a law those machines cannot be used.
Oh, man.
Go back to the butterfly ballots, not the Russian machines.
Oh, gosh.
Yeah. I mean, absurd.
Yeah. They say bucks.
Rubles.
Rubles, yes. Oh, my.
So, you know, this is about small claims court being cautious. You know, nobody called. Sometimes people don't call. This is what I found. And even Sadia, who's now been with me, has it been 2 weeks, 2.5 weeks? We get calls during the week. I heard Mr. Address on the radio. So I know some of you listen. You don't want to call in and talk about your case. I understand.
They may not want to interrupt you either.
I appreciate you then calling our office. But when you don't call me during this hour, all you get is a monologue. Now, I can talk. That's not a problem. But that's all you get to listen to. And I don't listen to myself on the radio. I don't know how interesting or not I really am.
Cover some great topics. I mean, you know, and this is stuff we don't know. I mean, this is all gee whiz stuff.
Well, you know, that's why there are lawyers. That's why there are plumbers. That's why there are electricians. You know, policemen, firefighters. Name any biologists.
Mm-hmm.
Name any occupation that exists. There are reasons that people go into it, and there are reasons that other people need their services. And it ranges from the superstar to the charlatan in any occupation or profession. One quick example, I won't mention any names at all, but for over a decade, I went to an endocrinologist who I really liked and who I think was a good endocrinologist. I really do. And he retired and recommended somebody else in West Palm. And I go, oh, West Palm, no, come on. But I went. It was a Cleveland Clinic, which, of course, now is here and everywhere.
Sure.
And I learned the difference between a good endocrinologist, which I had, and an absolute superstar. The difference was night and day. And it was not that my endocrinologist was bad. He wasn't. He just wasn't a superstar.
Mm-hmm.
The difference is extraordinary. Now, does that mean when we now transfer this to lawyers? You call two lawyers. One says, it's an hourly case. One says, I'll charge you $3.25 an hour. The other says, I'm going to charge you $3.75 an hour. And a third one says it's $400. Is the $400 one better than the $325? Maybe, but not necessarily. Is the $395 better than the $325 or the $400? Maybe, not necessarily. What do I tell people to decide on? First, if you've only talked to them on the phone, what was your reaction? Second, if you've at least met with them, what was your impression? And third, do your research. I mean, for example, I know on this site called Avvo, avvo.com.
Yeah. Yep.
I think it's 56 client reviews. And I know what they say because I give them out in a folder to people. And I tell people, look, anybody can say anything nice about anybody. So, you know, whether you're hiring a plumber or a lawyer, don't just look at 2 or 3 reviews and think that that's the gospel, because my son could have written it. But if you get to 10 reviews, 20 reviews, 30 reviews, 1,000 reviews, and you pick 10 of them at random, and you start seeing similar themes, always responds to calls, always lets me know, always gives me my options. Okay, then I say, whether it's a plumber or an electrician or me as a lawyer, you can start to believe that that's who that person really is.
You're doing the job. Yeah.
Okay?
Yeah.
So it's not just the hourly rate. If it's an hourly case, a lot of cases are contingency cases, depending upon what they are. Discrimination, sexual harassment, civil rights, those are contingency cases. But if you come to me with a case that, your neighbor built their fence 3 feet onto your property, that's going to be an hourly case. And you're going to want to get the best value for your money. That doesn't necessarily mean the cheapest lawyer. Now, it might be the cheapest lawyer is the one you're most comfortable with, in which case, hire the cheapest lawyer.
I look for credentials.
Well, if other people have said they've had good luck with this person, and you felt
that too,
and
yeah.
you felt a connection with this person, then that's the best lawyer for you. But don't assume that the cheapest of anything is the best, and don't assume that the most expensive of anything is the best, because that's not true either. Typically, somewhere in the middle is where you get quality.
Mm-hmm.
Okay. And so when people say to me, well, this other lawyer, is $25 or $50 an hour less than you, can you do anything? Okay. Look, I love that. I'm not offended by it. I do it to people. Okay.
I really don't like that, though.
It's the art of negotiation.
I guess.
Okay?
Yeah.
Too many people don't do it, actually. Too many people pay list price at a car lot. That's where they get highway robbery.
Mm-hmm.
They make $100 on me and $5,000 on you. Okay? Too many people don't even try to negotiate. But, okay, there are some things that really aren't the types of things you negotiate. No harm in asking. But when somebody, asks me that question, it depends upon the case. Very often I'll say to the person, if you felt more comfortable with that other lawyer, then go with the other lawyer. But if you feel more comfortable with me, there's probably a reason for it. And I stick to my guns. Now, depending upon the situation, maybe I will negotiate a little bit my rate. If I think it's a case I really want, if it's a case that, for whatever reason, I can cut a little bit here and there, I might do it. But for the most part, it's, this is what the fees are. And you're either, you're willing to pay them or you're not. Now, look, I can try to work as economically as possible, but I can't promise anything. I have clients. I have one client many years ago, a business client, thank goodness, they could deduct it. I had one client who over the course of 2.5 years paid me $200,000. It was a big, big dispute between two diabetic supply firms.
Oh, boy.
And what did that client get for $200,000? Not much, because I was attorney number 3 on the file, and then when he got unhappy with me, he went to attorney number 4.
Wow.
I'm sure that client in the end wasn't very happy with me. But, what can I do? Now, there are other clients who may spend a lot less on me and get great results. It runs the gamut, which is why when I do see a nice review come in, I appreciate it. And I look at what did they really say, because that tells me something. And then I have, if you come into my office, I have a bookcase where I have mementos. There are clients that will buy me mementos after a case is over, like a bottle of Goldschlager. It's not for me to open and drink.
It's for the bookcase.
It's for me to look at the little gold flecks and remember the testimony of some kid who was going to buy a case of Goldschlager, empty out all the liquor, and sell the gold. I have a sheriff's hat from a client who had a civil rights case against a sheriff's office up in the Panhandle. So clients sometimes buy you little gifts and that relate to their case, and you're always able to look at them and remember, really what the case was about. And then some of them, of course, have been written up in articles, and so they're posted in plaques in the office.
So do you have a scrapbook too?
No, I don't have a scrapbook. I've never kept a scrapbook of all the articles. I see lawyers' offices where they do.
I've seen those.
I guess nobody ever did it for me. I never did it for myself. The ones that I really thought were great, I turned into, little plaques that got put up on the wall. I guess there are other articles out there, but sometimes if you Google them, you can find them, but sometimes they're gone. They're just into the ether. So we only have a couple minutes left. We get that 2-minute warning. You know, some quarterbacks are great in that 2-minute warning. Others aren't.
So what about this national competition in Gatorland?
Don't get me started on that Michigas.
Yeah. So
I've got to
how many other schools are there?
Well, I'm not sure how many other schools you got. As I mentioned last week, there are 10 different states being represented.
Wow.
And I know there are approximately 700 students. And in my son's event, Lincoln Douglas Debating, he has 130 competitors. Whew. Only the top, in his category, only the top 8, those who make the quarterfinals, qualify for the national championships. So, you know, we're not expecting my son to qualify for national championships in this event. There will be a smaller event where he may have a better shot, you know, the Florida State Championships. But this will be excellent experience for him. An excellent you know, I've heard long-distance runners, we're about out of time, say that no matter how hard they train, they can't get their best time unless somebody's running next to them, pushing them. So this is a chance for him to be pushed by the best in the country and come back 2 weeks later in Palm Beach and hopefully do really good against the local competition.
That's what it's all about.
Anyway, this is Stuart Address. This has been Ask a Lawyer. I hope you've enjoyed listening. I won't be back next Friday because I will be in Gainesville, but I will be back the week following. Have a good weekend and have a wonderful week. Thank you.
You've been listening to Ask a Lawyer right here on WPSL, Port St. Lucie, WPSL.com, webcaster to the world on Alexa and Google Home.